It is now my honor to introduce to you Hans Vorländer, who is the presenter of the next speech. He is a professor of political science and chair of political theory and history of political thought. He is also the chairman and speaker of the Collaborative Research Center SFB, Sonderforschungsbereich Transcendence und Gemeinsinn, Transcendence and Common Sense at the Technical University of Dresden. He has studied law, political science, philosophy, sociology at the universities of Bonn and Geneva. His PhD is in political science from Bonn and his habilitation in 1991 from the University of Essen. He has held a number of academic positions, including senior director and lecturer at the Theodor Heuss Academy. I share with him the fortunate fate of having been a John F. Kennedy Memorial Fellow at the Center for European Studies at Harvard University. He has been the president of the German Association of Political Science. In America, this would be about the most prestigious attribute in a person's curriculum vitae. He is the co-editor of the Zeitschrift für Politikwissenschaft. He's been a visiting professor at the Universidad Nacional Autónoma de Mexico. Did I pronounce this correctly? E&T, of course, has published widely. I have a long list of publications here on the abbreviated CV that's in front of me. Maybe I will just mention your most recent edited volume, Demokratie und Transcendence, die Begründung politischer Ordnungen, published just last year in 2013. So it is a great pleasure to introduce you and to announce the title of your presentation, Validity, Narratives and Validity Cultures. Hans Vorländer, thank you very much for being here, and we look forward to hearing your talk.
Thank you very much for inviting me and for introducing me. And it's a great pleasure to be here and an honor. It's always nice to be back at the place where you got your academic education, both at the Faculty of Law and Faculty of Philosophy. So I just take up where we left off a couple of minutes ago, and I'm speaking very much about validity narratives, not so much on validity cultures, and I'm taking a very descriptive analytical approach, so from the standpoint of an observer, not from the standpoint of an actor. What are validity narratives? Validity narratives are narratives which create and try to preserve validity. Or one could take your nice trias I like very much. They are entailing, generating, and regulating validity. They are mechanisms which aim to generate and assert normativity. Validity narratives create a horizon of meaning and behavior, which Max Weber, to come back to Weber, outlines through the exemplary status and the binding force of an order, and which increases, Weber, the probability that actions will be oriented towards the normativity claiming order. With other words, social and political orders draw their validity by no means only from interest, not only from the regularity of settled habituation, which Weber called custom. Instrumentally rational motives, recreationale Motive, as well as settled patterns of behavior, do not transform an unstable into a stable social and political order. I would like to stress that only the meaning, der Sinn, of an order opens up the chance of the kind of legitimacy which can orient behavior and establish an order permanently. Furthermore, only on the assumption of legitimacy can an order generate Einverständnishandeln, consensual action, which rests as community action on the expectation that others too gear their actions towards the generalized expectations because they assume that these expectations are meaningfully valid. Thus, validity narratives make explicit the meaning of an institutional order. They create behavioral expectations and enable consensual action, Einverständnishandel. So in the following, I'm drawing very much on the research we've done in Dresden the last couple of years and drawing on the concept of institutional analysis and drawing on empirical research. So in the following, this fundamental exposition or thesis shall be explained briefly and developed in two aspects. Firstly, it will be argued that validity narratives have a specific relation to orders, as they are able to ground and legitimize social and or political orders. Orders are here not understood as fixed, timeless orders, which are removed from all the contingencies of the course of time. Instead, orders appear unstable, subject to historical change, and their duration is far from self-evident. Thus, order should be understood rather as symbolic orders, that's the key notion, the symbolic orders, whose stabilization is achieved not least through the representation of their leading principles and ideas. I would call it a self-conceptualization, Selbstkonzeptualisierung, which generates validity assertions and validity complexes, whose task is to portray the order, its beginning, and its continuous development precisely not as unstable and contingent, but as necessary and permanent. So this is this kind of involvement of fictionalizing from the standpoint of an observer. The decisive stabilizing achievement lies thereby in the development of validity narratives, which represent a specific arrangement of historical circumstances in view of the continuity of its own form of existence. Orders normally make explicit the fact that they are the subjects of their own historicity for the purpose of outside legitimization or self-affirmation of their identity. Yet as their genuine achievement lies in the strengthening of their own patterns, they cannot really be concerned about the depiction of processuality, but must rather aim to refer to eternalized traditions. Thereby orders deliver a dehistoricized history, a history without historicity, of their own existence. 2 points are important here. On the one hand, it is important to depict the own beginning in such a way that it seems to set the standard for all that follows afterwards. In a successful case, this generates proper foundation myths, Gründungsmythen. On the other hand, all depends on showing that there exists between the beginning and the present an unbroken chain of concrete actions which honor their primordial qualities. An example of establishing legitimacy in that way can be found in genealogies of the aristocracy, in genealogies of ideas and institutions. Fictions of the real continuity of parliamentarism, for example, which today is traced back seamlessly from the mother of all parliaments, either the Athenian Ecclesia or the British Parliament, pretend to be historical and are yet totally ahistorical, as it gives the impression that it has always been that way. This mechanism, which creates validity, harbors considerable advantages for political and social orders. It produces a detiming of events, which takes away from the past all contingency of change, and which shows in each moment of history the unchanging as present. Temporality is transformed into permanence, variability into uniformity, and with that the core of the institutional achievement is realized. Validity narratives are also narratives which, given the change and transiency of past validities, try to prove that social and political orders also principally have timeless validity. They try by doing so to establish a stable horizon of normativity. Secondly, we have to ask how exactly a narrative can generate validity, or, to phrase it differently, how validity narratives generate and preserve normativity. History, according to Hannah Arendt, consists of nothing else than of stories. Stories give life meaning and build a shared relation to the world, the interrelationship of human affairs. Stories are the real products of action and speech. They provide, I quote Arendt, a remedy for the frailty of human affairs. However, the continuum of time which is depicted in the narratives exists, as Arthur C. Dento has shown in his analytics of history, always, quote, only in the narrative construction of the story, unquote, and is a product of the, quote, unifying achievement of the storyteller, unquote. Continuity is not inscribed in a social and political order, it is narratively constructed and ascribed to the order. If validity narratives are such narratives which assert the validity of an institutional order, and they by aim to secure their continuity, then we still have to ask how a narrative achieves the validity which is to secure the assertion of continuity. Narratives are to be understood as medium, charged with validity, which materialize in the forms of stories, texts, even discursive treaties, or even statutes. The narratives have an author, they have an interpreter or a narrator, and they do have an addressee. This threefold relation generates a field of validity in which the actual enforcement, acknowledgement, the recognition, and acceptance of the validity assertion is decided. Narratives tell us about the beginnings, the origins, and the founding of an institutional order. They remind us of the uniqueness of an exalted event or occurrence, and they can establish the exemplary as a model. So narratives combine retrospection with prospection. They can use ritual, sensorial forms, and hermeneutical operations. They can frame the narration legendarily, heraldically, or hagiographically. But validity narratives always need a specific communication situation, acts of communication, a context of action to gain and maintain validity. So it's always a complex interrelation between normativity and communicative practices which generate the validity of a validity narrative. In the following, I would like to illustrate these connections with the help of two examples, and I will illustrate the argument. And both address the problem of justifying and preserving an order. Following Hannah Arendt, I will ask firstly how one can explain the, quote Arendt, binding power of that which is founded, die bindende Macht des Gegründeten, which is a central problem of her book on revolution. Secondly, I will ask how a constitution manages to remain valid once it is instituted. For Hannah Arendt, it is an ancient idea of the Western world. Every beginning needs an absolute from which one can explain the beginning rationally. In most cases, it is the figure of the creator, a highest being, or an original lawgiver to which every beginning refers. There are also legends of origin or speculations of the beginning, which are to legitimate the new beginning and secure its ongoing legitimacy. It is the biblical story of the exodus of the children of Israel from Egypt, or Virgil's tale of the wandering of Aeneas after he had escaped from burning Troy. Both legends are about liberation from servitude and the escape from a certain extinction. And, quote, both stories are centered around a future promise of freedom, the eventual conquest of a promised land, or the foundation of a new city, unquote. The great leaders of such legends appear, quote, in a legendary time frame between beginning and end, between a no longer and a not yet, unquote. This hiatus, this gap, the speculation about the time between servitude and freedom, between annihilation and resurrection, should be read as attempts to solve, quote, the big unsolvable question of the beginning of the world or existence as such, unquote. Founding myths of origin, heroic leaders and great lawgivers are not only figures and metaphors which structure the great religious stories about the origin of the world, and which try to justify ancient communities through the medium of sagas and legends. Yet, modernity too has its histories. Its histories of origin, its founding legends, and founding figures. The United States of America, just to come back to this example, thus connects the revolutionary liberation from the English motherland, first of all with the charismatic founding fathers, Adams, Jefferson, and Washington, but also with those founding fathers of 1787, 1788, who created the American Constitution, which is still valid today. Hamilton Jay and Madison stand at the beginning of a sometimes cultic worship of the American Constitution, which is, together with the documents of the American Declaration of Independence, counted as belonging to the holy scriptures of the founding of America and of the American self-understanding. Look at this presentation in the rotunda of the Shadows of Freedom. It's like a shrine. So this is a location of sacredness. So it's innerworldly sacredness. The talk about New Jerusalem and the topos of God's chosen people also belong to the elements of a great American story of immigrants and founders who left the country of their oppression and who settled in a new promised land, which they constituted politically and made economically prosperous. Exodus and promises of the future, the promise of American life. You can't always looking at topos, which shows up at any moment of the history. The Declaration of Independence and the Constitution of 1787, together with the Bill of Rights from 1791, have been weaved into a narrative which transmits the founding moments and connects in a grand validity narrative the present with the past, and thereby creates a horizon of normativity, which serves as a partly critical, partly apologetic blueprint for the evaluation and confirmation of the respective present. So such narratives can be supportive or they can weaken the given political orders. But in any case, these are presentations which are inscenations which gives the idea of something that has a transcendental status, so status of transcendence which transcends a given society and relates back to the very beginning. Let me get, so here you have the National Mall, which can be seen as a narrative built in stones and streets and in buildings, so it's a great narrative in stones. Let me get to the second example, the Constitution. If you follow Hannah Arendt, then constitutions preserve the memory of the founding act of the political order. Connected with the Constitution is the hope that, quote, when constitutional questions in narrow sense come into play, the act itself, the beginning as such, is remembered. However, unquote, however, constitutions, although in modern circumstances connected to the founding act, relate less to the act of the foundation as such, but rather are directed in their aspiration to the future. If the Constitution wants to exist permanently and fulfill its normative and regulatory function, then it cannot derive its validity only from its genesis. Constitutions break free from their context of creation and cannot rest on their character as founding document. The Constitution here thereby confronts a paradox. Like every founding act, the Constitution breaks with an old order. It brings, at least most of the times, to a close a revolutionary change, But it also raises a claim of continuity for the order that it establishes itself. The question is therefore how the Constitution can extend its claim to normativity beyond the founding period of time. Thus, how can we explain what legal scholars call the normative force which is meant to secure the validity of the Constitution in the long run? The binding effect of the Constitution beyond the Founding Act results in no way only from the juridical rationality of the Constitution as a positive legal order, as one might expect from the legal talk about the normative force of the Constitution. The power to exert the sanctioning of divine behavior, which is generally associated with the law, applies only to a certain degree to the Constitution. The Constitution and its interpretation, even the judgment of the Constitutional Court, are not automatically executed. The Constitutional Court and thereby the Constitution remain powerless, whereas there is no willingness to follow the authoritative interpretations and decisions. The other powers, the executive and the legislative, have to lend the Constitution their executive and legal means of power. They have to adapt the decisions as their own and they have to implement it. The Constitutional Court itself does not have the means to secure the necessary support for its decisions through coercive force. Thus, it is an illusion to assume that the Constitution and the Constitutional Court on their own can have an imperative validity, a validity by der Satzung. Satzungs- oder Setzungsgeltung ist nicht das Entscheidende. Similarly, the binding force of the Constitution for the community of citizens cannot be guaranteed in the long run through the means of physical force. The acceptance of the Constitution and the trust in the constitutional adjudication is a precondition of the belief in the validity of the Constitution. The Constitution is fundamentally dependent with respect to its validity as an action guiding institution on symbolic forms of mediated representation and direct realization. Here the principles of the order, which can be traced back to its founding, are represented anew, updated, and thus imagined by the community of constitutional citizens. Based on these symbolic forms, the constitutional community is thus in the first place a community of imagination, which identifies the central ideas of the political order with the Constitution. Cultural forms of representations and presentations, like the experiencing of constitutional celebrations. Here one example of the early German constitutionalism of the early 19th century, the Galbacher Konstitutionssäule, which was an act of recognition of the constitution, which was given by the König der Bayerischen, König, the King of Bavaria. Or you have another possibility here to see the Constitution Day festivities 1929 in Berlin and in Weimar. These are constitutional celebrations. And we have another form of making the Constitution present, the embodiment of the Constitution. So the embodiment of the Constitution through the judges of the constitutional courts. Both elements, constitutional celebrations, commemorations on the one hand, and the embodiment of the Constitution as through the judges, merge the historicity of the Constitution, the difference between the past and the present, and structures of continuity. The authority of the founded is renewed through the medium of the Constitution by way of remembering and the collective experience. Founding myths and stories of origin, historically transmitted founding legends which rely on the beginning of an order as a touchstone for all that follows, connect the authorship of a constitution with the founders, the mothers and fathers of the Constitution. Here one tries to narratively, perpetuate and renew the memory of the creation of the Constitution and the founding of the political order. So founding myths and constitutional narratives belong therefore to the resources of constitutional validity. Constitutional celebrations and jubilees are mediums and generators of validity narratives and can, as not only the example of the USA can easily prove, be developed up into a constitutional cult. That is ritually solidified structure of validity creating narratives. On the other hand, the renovation is a renewed appropriation of the Constitution by a later generation, which is not tied to the original context, but to the original text, can also belong to different kind of founding myths and legends. Thus, for example, in the Federal Republic of Germany, the myth of 68, oh, sorry, this is a different story. That's the Declaration of Rights and of the Citizen in France, which is another validity culture, so to speak. So it's a different culture, which goes back to the era of the French Revolution. This is the Jour de la Fête célébrée, the highest being, être suprême. And this is the National Constitution Center, also a location of the commemoration and a recognition of the continuity of the American Constitution, newly built at Philadelphia. This is what I wanted to refer to. So a matter is to renew the importance and the normativity of a constitution is seen here just by protest against some statutes, the Federal Emergency Acts in 1968, which is another kind of recognition, a new recognition of the relevance of the Constitution. So it's a renewed appropriation of the Constitution by a later generation. And this myth of 68 is also a narrative point of reference for a second founding, especially here with regard to the controversy surrounding the emergency legislation and the role of the Constitutional Court in the another example is the role of the Constitutional Court in the assessment of societal reform projects in the 1970s. This form of specific renewed validation through generational specific appropriation points to conflicting civil society practices as a resource of validity. In this context, the validity resource can be the somehow limited, conflicting and diverging imaginations of order as competing attributions of meaning and validity to the constitutional text, and it can deliver specific and very strong normative perspective. Behind there's a lurking theory of integration by conflict, so it's a conflict theoretical approach. Yeah. In the American context, this paradox of conflicting validity consensus is described early on by Thurman Arnold. I quote, "It is essential to constitutionalism as a vital creed that it be capable of being used in this way on both sides of any moral question, because it must be the creed of all groups in order to function as a unifying symbol," unquote. A resource of validity can, however, also be the sheer duration of a constitution and the political order which is symbolized through the constitution as well as the good practice under a particular constitution. The topos of the best constitution we ever had, this is a narrative. The topos can be elaborated to a whole range narrative. The best constitution we ever had, or the constitution which has proven itself, are not only mobilized as reasons for validity, but also as an argument for the continuing validity and lastly also against a changing practice, or even against a refounding, as it happened when, in the course of the German reunification, a new constitution for Germany as a whole was discussed. The longer a constitution is in force, the more are narratives of origin superseded by actualizing narratives about the constitution. Those are generated by the community, or rather by the community of constitution interpreters. Validity narratives of the constitutions are created by authoritative interpreters, mostly where there are in the constitutional court, but also by the scientific and community or the communities of legal scholars, or by the public, as well by the broad public opinion. The adjudication of the constitutional court, the political and legal discourses around the constitution, the publicized and the public opinion are then the mediums and generators of validity narratives in which the imaginations of the order which are identified with the constitutions are enclosed discursively and representatively. It is then decided only through the public discourse of the constitutional community which of the validity narratives is accepted and recognized as authoritative. So we all have some historical context, is always a plurality of narratives. But in a given moment, there is a decision or a process that leads to recognition of one or plurality of narratives that are recognized. So validity narratives are thus very well capable of being debated and negotiated in a conflictual manner. It is therefore exactly the conflict of diverging validity narratives through a shared constitutional language in the narratives of constitutionalism, which is a superseding narrative, which gives the text of the constitution competing attributions of meaning, and through this enable a civilization and legitimation of the constitution. Let me just conclude by this is just one representation, picture showing the demonstration against the crucifix decision of the Federal Constitutional Court, which shows the civil society and the struggle against an interpretation. Just a nice picture showing depicting the officers of the East German National People's Army in a preparatory course, trying to learn what the German constitution is all about. And again, the constitutional court of the Federal Republic. There are two mechanisms in establishing a narrative and the adjudication of the constitutional court. A constitutional court is the authoritative interpreter, and it's a decisive institution for preserving the validity of a constitution. But the constitutional adjudication has to bridge the difference between past and present, between the founding act and the actual application of the constitution. Constitutional courts can hereby follow two strategies. One strategy is taking the historicity out, and the other strategy is bringing historicity in. The strategy, the first one, the strategy of detemporalization, tries to liberate the time between the founding and the actual moment of interpretive action. The temporalization strategy, on the other hand, relativizes the past and the change of the course of time which has happened since the founding and turns to a current interpretation. The time difference between the past of the founding and the presence of the assertion of validity is here not veiled, but instead made transparent. When constitutional courts use the detemporalization strategy, they simulate that their current understanding of the constitutional idea of the order, which they explicitly use in their decision, is identical with that of the past constitution and the genesis of the constitution. For that purpose, legal techniques and methods of interpretation are used, which are mechanisms for the constructions of validity assertions. Through legal methods of constitutional interpretation and also through argumentative positions of original intent or non-interpretativism, it is tried to bridge the gap between the codification of constitutional principles and their current validity by using specific argument of method of constitutional interpretation. The temporalization strategy, on the other hand, emphasizes the continuous change and adaptation of the original constitutional text to the changing course of time. The construction of a history of its own through the setting of precedents, we talked about it this morning. For example, the practice of stare decisis or the binding effect of decisions for constitutional interpretation itself belong to this strategy. A radical variety of regarding change as a resource of validity is the activity of the constitutional courts, in which they very explicitly invent and often offensively justify a new norm or new ordering principle. This is the census decision where they invented the right of informational self-determination. A surprising quick turn in the adjudication should also include it in those forms of radical time-oriented reinterpretations. Here, constitutional interpretation achieves at the same time the status of authorship of a totally different, in parts newly constituted constitution. The appeal to the genesis of the constitutions happens at most as an interpretative aid to connect the validity to the traditional spirit of the constitution. In principle, however, this strategy is an interpretive self-empowerment to authorship of the narrative. Examples can be found in the surprising turn in the American constitutional jurisdiction in the transition to the New Deal period of 1936-1937, which was 36-37, which was, however, caused by political pressure, and also in the invention of a new basic right to informational self-determination through the German Federal Constitutional Court. It becomes clear, I'm concluding, from these examples that validity narratives do not at all aim only to achieve a detemporalization, which mark the time span between the beginning and the present as an unbroken chain of concrete enactments of the primordial qualities of the founding situation, and which thereby take away the contingency of change from the past. Instead, validity narratives also require sometimes a radical temporal interpretive renewal, precisely to be able to perform their stabilizing capacity. It is especially this form of the revision of validity narratives which appears to be necessary to avert a crisis of the Constitution and to secure the continuation of the auctorial interpreter. Thank you very much for your attention.